Hello and welcome to our webinar, Brexit, the Implications for Employment and Immigration Law. My name is Louise Merrill. I'm a Senior Solicitor at Clarkslegal within the Employment and Immigration team.
And my name is David Shepherd. I am also a Senior Solicitor within the Employment and Immigration team.
This webinar is going to be approximately 30 minutes long, which includes some time at the end for questions. We're going to be covering what we mean by Brexit, how the EU impacts on UK employment and immigration law at present, the mechanism that will be used to effect Brexit, and by this we mean the procedure set out in Article 50 of the Consolidated European Treaties, the potential impact Brexit could have on UK employment law, both in terms of existing and new legislation and also case law, and the potential impact Brexit could have on UK immigration law. So what do we mean by Brexit? Put simply, as I'm sure everyone listening is aware, the term Brexit refers to the UK's possible departure from the EU following the national referendum on the 23rd of June. Before we consider the potential impact of a leave vote on UK employment and immigration law, we're going to talk through a bit of the background of the European Union and the influence of European law on employment and immigration law in the UK.
So how did the European Union come into being? Following the devastation of World War II, it was considered that more important than ever to build strong international relationships. In 1951, 6 neighbouring countries, France, Germany, Italy, the Netherlands, Belgium and Luxembourg, signed the Treaty of Paris, which established the European Coal and Steel Community. This essentially created an area of free trade for key resources like coal and steel, which had a key role in industry and the military. Britain declined an invitation to join the founding countries in 1957. In 1958, the European Economic Community and the European Atomic Energy Community were established alongside the European Coal and Steel Community, and in 1967 these 3 communities merged to become known as the European Economic Community, often referred to by its abbreviation, the EEC. Britain applied to join the EEC in 1961, but this was vetoed twice by the then French President, who believed Britain was only interested in creating stronger links with the US. The UK, together with Denmark and Ireland, joined the EEC in 1973 after the French President had left office. The European Communities Act of 1972 was enacted, giving European law supremacy over domestic law. As a latecomer to the EU, the UK had to learn to accommodate pre-established policies and rules, some of which conflicted with key principles of the British Constitution, such as the sovereignty of Parliament. In 1975, shortly after joining the EEC, the Labour Prime Minister Harold Wilson held a referendum on Britain's membership of the EEC, which saw the majority of voters opting to remain in the EEC. Margaret Thatcher, who became Prime Minister in 1979, had an openly negative attitude to the EEC. Among other things, Margaret Thatcher listed suggestions for the UK to join the European monetary system, which would adopt a single currency, and to adopt a common social policy. When John Major replaced Mrs Thatcher, he signed the Treaty on the European Union, which led to the formation of the EU in 1993. This transferred significant power to the EU, although Britain secured opt-outs from a single currency and the social chapter. The UK still retains its own currency. There have been further treaties reforming the EU to get it to the form we recognise today. Most notably the Treaty of Amsterdam, signed in 1997, the Treaty of Nice, signed in 2001, and the Treaty of Lisbon, signed in 2007. The Lisbon Treaty introduced a legal right for member states to leave the EU, which will be relied upon by the UK should the referendum result in a vote to leave. We will discuss this in more detail later on. A significant amount of UK employment law is derived from EU law, so let's now take a look at the key sources of European law. Firstly, there's primary legislation. The EU treaties themselves. By EU treaties, I'm referring to the Treaty on EU and the Treaty on the Function of the EU. We refer to these in their consolidated form as the EU treaties. These treaties have direct effect and can be enforced by individuals against the state, and in some cases against other individuals. By direct effect we mean that they can be relied upon as law without the need for domestic legislation to implement them. Then we have secondary legislation, the main ones being regulations and directives. Regulations also have direct effect. These automatically override any conflicting domestic provisions. An example of this would be the forthcoming EU General Data Protection Regulation, which we'll touch upon a bit more detail later on. Directives are far more common. There are over 35 directives which have impacted on UK employment law. Directives do not have direct effect. These are, in essence, a piece of legislation setting out the ultimate goal for the member states to achieve, but it's up to each member state to enact legislation to reach this goal. Member states are given a set time to implement directives, usually 2 years. Examples of UK legislation which came from directives include the Working Time Regulations, 2P, and the Agency Worker Regulations. In addition to EU legislation, UK courts are required to interpret domestic legislation as far as is possible to give effect to the EU law. The approach of the English courts has been to look at any relevant EU law and its purpose and endeavour to interpret that into the national legislation. The recent decisions of the courts on holiday pay and carryover of holiday during periods of sickness demonstrate this approach, where the UK courts have read specific additional words into the domestic legislation to give effect to the purpose behind the directive. If the National Court cannot answer a question of EU law or needs assistance, it can make a reference to the Court of Justice of the European Union, more frequently referred to as the ECJ. The ECJ will then answer the questions posed to it, which the referring court will then need to apply to the facts. So let's take a look at a practical example of the influence that European law has by working through a day in life of an employee.
Mr. Smith works for a large company. Men and women in the team are paid the same. This point obviously relates to equal pay. The UK did have its own domestic legislation on equal pay prior to joining the EU, the Equal Pay Act 1970. However, Article 157 of the Treaty on the Functioning of the EU extended the principles of equal pay for equal work, which were then implemented into domestic law by the Equality Act 2010. Further, ECJ case law has been significant in developing equal pay law and clarifying key points of law. By way of example, the ECJ clarified that a woman did not need to compare her pay to a male colleague employed at the same time, but could also compare her pay to that of a male colleague who preceded her into her role.
Moving on, let's look at the next 2 points together. Mr. Smith starts at work at 9 AM. He finished work at 7 PM the previous day. He stops for a lunch hour at 1 PM. These are referring to rest periods and breaks contained within the Working Time Regulations 1998, which were implemented following the European Working Time Directive. Under these regulations, workers are entitled to a minimum daily rest period of 11 hours and a rest break of 20 minutes when their working time exceeds 6 hours. It contains a further weekly rest period of 24 hours or 48 hours per fortnight. It's worth noting that in reality, as is the case with Mr. Smith, many employers in the UK give their workers longer periods of rest. Working time was largely unregulated by statute before the introduction of the Working Time Regulations in 1998. The few statutory provisions that did exist were confined to certain sectors and activities such as factory working, mining and driving. Many had also been repealed by the previous Conservative government. For example, there were statutory restrictions on the working hours of women employed in factories and mines, but these were revoked by the Sex Discrimination Act 1986 and the Employment Act of 1989. Additionally, it needs to be remembered that employers were, and continue to be, subject to a duty to protect the health and safety of their workers, which is likely to involve the consideration of adequate rest breaks. This is something that the UK will remain bound by, even if the UK leaves the EU.
So back to Mr. Smith. Mr. Smith eats lunch with his colleagues in the staff canteen, many of whom are agency workers. This point highlights the impact of the Agency Worker Regulations 2010, the result of another EU directive, the Temporary Workers Directive. Under these regulations, agency workers are given more rights, including the right not to be treated less favourably than a direct recruit of the hirer in relation to access to collective facilities and amenities, such as a staff canteen. They also give agency workers the right to the same basic working and employment conditions as direct recruits after 12 weeks. Prior to the introduction of the Agency Worker Regulations, agency workers did not have these rights, and particularly with regards to pay, which is often the more controversial subject, they could be paid a lower rate than direct hirers. However, the Agency Worker Regulations will not affect an agency worker's employment status, and they do not give the agency worker full employment law rights, such as the right to claim unfair dismissal.
After lunch, Mr. Smith gives his line manager an annual leave request for his summer holiday. This is another reference to the working time regulations, which entitle workers to 5.6 weeks paid annual leave per year. EU law actually only specifies 4 weeks annual leave. However, the UK decided to extend this right, largely to take into account of bank holidays. As mentioned previously, working time was largely unregulated by statute in the past. However, the UK did have legislation in place around paid holiday prior to joining the EU, such as the 1938 Holiday with Pay Act, albeit it was not as extensive as the rights we enjoy today.
Mr. Smith's friend arrives at work in the afternoon and is told that his staff discount is being removed as it is now only available for full-time workers. This point relates to the Part-Time Workers Prevention of Less Favourable Treatment Regulations 2000, which implement the EU Part-Time Work Directive. This established the right of part-time workers not to be subjected to less favourable treatment because of their part-time status, which could include denial of service-related benefits and lower rates of pay. Until the part-time workers regulations came into force, part-timers were typically left to address differential treatment by relying on laws relating to sex discrimination and equal pay, on the basis that most part-time workers are women.
Mr. Smith then leaves work at 5 p.m. having completed a 48-hour week. As before, this refers to the working time regulations, which state that a worker's average working time, including all overtime and time spent working for others, must not exceed 48 hours per week. However, in the UK, a worker has the ability to opt out of this.
As he is leaving, he overhears a colleague say that the company is potentially being taken over by another company. This point brings us to the Transfer of Undertakings Protection of Employment Regulation 2006, or TUPE. TUPE was enacted pursuant to the European Acquired Rights Directive. TUPE seeks to safeguard employees' rights on the transfer of a business or service, and amongst other things introduces the automatic transfer principle. This is the principle that certain employees will transfer automatically to the new employer under their existing terms. Prior to 1981, when TUPE was first enacted, sellers and buyers could choose which employees transferred and on what terms. Further, there was no general obligation to inform or consult with representatives of the employees unless there were to be collective redundancies.
And finally, Mr. Smith believes that if this is true, there are likely to be large-scale redundancies. This point is really just to highlight the Trade Union and Labour Relations Act of 1992, which implements the European Collective Redundancies Directive. Broadly speaking, the Act states that where an employer proposes to make redundancies of 20 or more employees within a period of 90 days or less, it must consult on its proposal with representatives of the affected employees, a procedure that did not exist previously. It's important to note that whilst EU law has significantly influenced employment law in the UK, this does not mean to say that the UK would not have had similar or equivalent legislation in place if it was not within the EU. Many EU laws reflect established international standards and simply replicate or augment existing UK laws. For example, equal pay and most other discrimination laws.
So turning now to immigration, the member states of the EU plus the 4 member states of the European Free Trade Association, namely Iceland, Liechtenstein, Norway and Switzerland, are all members of the European Economic Area, or EEA for short. If you are a citizen of an EEA country, then you can come to the UK as a qualified person. You don't need to apply for permission, for example visas or residence cards. You can come over on the basis of your citizenship, and there's also no maximum length of stay. A qualified person is someone who is studying, self-employed, self-sufficient or looking for work, or someone who has a family member who is a qualified person. And family members will cover spouses and civil partners, children or grandchildren under 21, and dependent parents or grandparents. This can obviously therefore catch non-EEA citizens, for example an American who's married to a French person. You can also come to the UK if you're an extended family member of an EEA national, for example a brother, sister, aunt, uncle, cousin, niece or nephew. However, you must also have lived in the same house as the EEA national before and after coming to the UK, or you must have a serious medical condition which means that you need their personal care.
Let's now shift our attention to Brexit and consider a procedure that applies for member states leaving the EU. Back in February this year, David Cameron said that if the people vote to leave, there is only one way to bring that about, namely to trigger Article 50 of the treaties and begin the process of exit, and the British people would rightly expect that to start straight away. So what is this Article 50? Article 50 of the EU Treaty sets out the legal mechanism for a member state to exit the EU. Let's take a few minutes to go through this. The first stage will be for the UK to give notice of its intention to leave the EU. Negotiations will commence between the UK and the European Council to reach agreement on the arrangements for the UK's withdrawal, taking into account of the framework for its future relationship with the Union. This agreement must then be agreed by Parliament and a qualified majority of the European Council, which means 20 of the 27 remaining member states will be required to agree its contents. Exit will take effect from the date of entry into force of the agreement, or failing that, 2 years after the notice was given, unless the UK and the Council agree to an extension. On this occasion, the Council's agreement must be unanimous, and so it will need all 27 remaining member states to agree an extension. Therefore, whilst the UK may require an extension, any one of the remaining 27 member states could block this, leading to an exit from the EU without a clear withdrawal agreement having been negotiated. In summary, whilst the process for Brexit could be triggered immediately, we won't see any changes to employment and immigration law overnight. Given the complexity of the UK's relationship with the EU and the fact that Article 50 has never been used before and is thus untested, it is likely that the UK will remain part of the EU for at least 2 years after the referendum.
So what's in store for employment law? Essentially, the answer here is that we cannot know for sure. We can make some predictions, but as Article 50 has not been used before, we're all a bit in the dark on this one. Let's take a look at the impact Brexit may have on legislation first, and then we'll turn to the case law. Firstly, it is likely that the UK will want to maintain an existing relationship of trade with the EU, which may result in its continued compliance with EU law in any event. For example, it could adopt a similar approach to Norway and join the EEA. However, as part of its arrangements, Norway is still subject to many EU laws, and it pays nearly as much per head of population to the EU as the UK do now. The government have already suggested that this would not be a desired approach for the UK, as it would mean that the UK would remain bound by EU law but could no longer influence them. Alternatively, the UK may decide to enter into a free trade agreement of some kind. However, the EU is likely to impose a condition on the UK to continue to comply with its key EU laws in this case. For one, allowing the UK to benefit from free trade whilst having more relaxed employment laws may decrease the competitiveness of the EU member states, which obviously the EU would not be keen to do. If the UK did leave the EU without agreeing to continue to comply with its laws, then the UK government will have to make decisions on whether to retain, amend or repeal the laws created pursuant to European law. A removal of all EU-derived laws is extremely unlikely. They're firmly entrenched in the UK employment law, and for many laws there's just no demand to change them. The changes will depend on the government of the day. However, assuming the current government are still in place, it is believed that those on your screens are the most at risk, which I'll briefly comment on. First, we have the working time regulations. These are one of the most expensive EU regulations for businesses, and many businesses experience administrative difficulties in complying with these. It is highly unlikely that all of the provisions will be repealed. They are very popular, and let's face it, it would be political suicide for a party to try to remove rights such as the entitlement to paid annual leave. However, it is likely that the working time regulations will be amended to relieve some of the administrative burden on employers. In particular, employers find it difficult to keep track of a worker's hours for the purposes of the 48-hour limit, particularly as these hours include those worked with other employers, and it's therefore quite possible that this 48-hour limit will be removed. The regulations have, of course, also come under increased scrutiny recently following the decisions on holiday pay, and it may be that we see the government intervene here to carve out more complex payments from holiday pay calculations, such as non-guaranteed overtime. It may even decide to amend the legislation to revert back to the basic pay principle, which many employers applied pre-cases such as Locke and Bear Scotland in an attempt to simplify the law in this area. Next we have 2P. 2P is a complex area of law and one which is often perceived as overly burdensome on employers. Again, it's unlikely that 2P would be repealed, particularly as UK legislation actually goes further than the directive required. However, it is likely that the provisions of 2P will be relaxed, building on the changes made in 2014 to make contract harmonisation easier following a 2P transfer. Finally, we have the agency worker regulations. This is an area most likely to be significantly amended or repealed. As a relatively recent piece of legislation, it has not got to the stage of being too difficult to remove and is perceived as being costly and onerous for employers. In addition to the changes I've talked through, there's also speculation about further changes to employment law. For example, the introduction of a cap on compensation in discrimination claims, similar to that which applies now in unfair dismissal claims. Even if there is a desire to make changes, it should be borne in mind that many EU-derived rights will have been incorporated into individuals' employment contracts, making them difficult to change. If employers wish to make changes to employees' contracts to reflect any new legal position, this could lead to potential large-scale termination and re-engagement proposals and the risks that come with these processes.
So what happens with any new laws the EU pass? Will the UK have to comply? Again, the answer is unclear. It seems likely that any new EU law would be made via EU directives, given that they are the most common source of EU law. There's a possibility that, given the 2-year implementation timeframe, the UK may have exited the EU by the time the law is due to be implemented. However, as we don't know how long the exit negotiations will take, it is more likely that the UK will seek agreement to be released from the need to comply as part of any exit negotiations. The position will be more complex for laws already in progress, however. The EU General Direct Data Protection Regulation has recently been published and will be directly applicable and enforceable in all EU countries by the 25th of May 2018. Assuming the UK does not conclude its exit agreement before the 2-year timeframe, in Article 50, it will presumably be bound by this regulation. Whilst it is likely that the exit negotiations will try to address this, it leaves companies in the precarious position of not knowing whether to start taking measures to ensure compliance with the new regulation in 2018. We would expect the Information Commissioner's Office, who regulates data protection in the UK, to provide some guidance on this should the UK vote to leave the EU. Let's turn now to UK case law and how this may be impacted. Many cases have been interpreted in line with EU law, and it seems likely that, if the UK leaves the EU, new claims on related issues may seek to distinguish these decisions on the basis that EU law no longer applies. However, the UK implementing legislation was enacted with the purpose of giving effect to the directive. Thus, Parliament's intention at the point of drafting this must have been to comply with the directive. With this in mind, the question arises, should the UK courts now depart from EU decisions where they appear inconsistent with the wording of the UK statutes, or should they continue to be influenced by EU law on the basis this would have been Parliament's intention at the time? The presumption is that it will be the latter.
So what's in store for immigration law? Obviously, a central right of EU citizens is to move freely across the EU. If the UK were to leave the EU, then in the absence of any agreement to the contrary, this would no longer be the case. Pro-Brexit campaigners say that exiting the EU will allow Britain to stem the relatively recent influx of EU migrants to the UK. However, if the UK wants access to the single market, the most obvious way to do that would be for it to become a member of the EEA, which I touched on before. Free movement applies to EEA members in pretty much the same way as EU members, so just coming out of the EU might not actually mean an end to free movement at all. It may be that the UK will negotiate bilateral agreements to ensure freedom of movement. However, this has been done already in some countries, and the EU has continued to exact its influence. By way of example, Switzerland had bilateral agreements for market access in 2014, and they voted in a referendum to impose immigration quotas. The EU responded to this and made it clear that this ran contrary to EU free movement principles and effectively threatened the agreements that underpinned Switzerland's access to the single market. Switzerland didn't end up imposing the quotas, and they're now thinking about another referendum later this year proposing less stringent immigration control. And what of those UK nationals and their families already living and working in the EU? The UK would not want to repatriate such individuals and would no doubt be looking to safeguard their position by reaching an agreement to allow them to remain. That would almost certainly mean Britain agreeing to safeguard the position of EU nationals and their families already in the UK. If Britain were to leave the EU free movement area, immigration policy would probably change quite a bit from the current position, especially if the government at the time remained committed to reducing net migration numbers. For example, there might be a crackdown on unskilled economic migrants to reduce numbers. However, that's likely to have a pretty significant negative impact on business, with areas like the NHS and other care and health services being hit quite hard.
That's everything we wanted to cover. I would like to add that there have been a few areas which we have touched upon but not gone into detail for the purpose of today's webinar, like 2P, working time and immigration. Our Employment Buddy fact sheets contain a lot of information on these areas of law, and they are well worth a look for anyone who wants to understand these areas of law better. Just go to www.employmentbuddy.com. We've left a bit of time to answer some questions now which have come in during the webinar. There have been quite a few, so it's an obviously a popular topic. So Megan, can we have a couple of these, please?
Yeah, sure. So we've got, if the UK vote exit, will current decisions of the European Court of Justice and the European Court of Human Rights still be taken into account by the UK courts?
I can take this one. If the UK leave the EU, then yes, in theory, the decisions of the ECJ are no longer binding, and we may see that judges feel more able and willing to depart from the ECJ decisions in the future. However, we touched on it briefly earlier, but the ECJ interpret the directive, and as UK law was implemented to give effect to the directive, the ECJ interpretations and their decisions may well still influence the UK courts if they're trying to decide what Parliament's intention was behind the Act. Also, it's worth mentioning that UK courts have followed ECJ decisions, and so there's a plethora of domestic case law which will bind UK courts, and they'll need to take these into account even if they do decide to distinguish these. So that's the ECJ, but the second part of that question was regarding the European Court of Human Rights. So the European Court of Human Rights is actually not an institution of the European Union. It's a court that's linked to the European Convention on Human Rights, and that was implemented into UK law by the Human Rights Act 1998. It's not impacted by Brexit per se, but if the government intends to push forward with its plans to introduce the new British Bill of Rights in place of the Human Rights Act, then I suspect it may well do so to coincide with the UK's exit.
Have we got any other questions, Megan?
Yeah, we've got, will employees' rights to bring unfair dismissal claims be affected by Brexit?
Well, I'll take this one. Yeah, as we discussed in our presentation, following the Brexit, there's likely to be a 2-year period in which the terms of the UK's exit will be negotiated. So any EU-based employment rights will continue at least for this 2-year period, and their future content will obviously depend on prevailing political circumstances and the government of the day. So laws may change, they may remain unchanged, they may be repealed. Obviously it's difficult to predict what will happen. But regarding unfair dismissal, it's important to remember that this isn't an EU-based right. This is a wholly UK-based right currently set out in the Employment Rights Act 1996. And it was originally established for UK workers via the Industrial Relations Act of 1971. So actually this right predates the UK's membership of the EEC as implemented in 1973. And since then, the concept of reasonableness and the fairness of dismissal has been developed by industrial and employment tribunals and the UK appeal courts. And the European Court of Justice has had no jurisdiction on the interpretation of fairness and reasonableness within the context of unfair dismissal. There is a degree of overlap between unfair dismissal and EU rights in that certain automatically unfair reasons for dismissal, such as certain rights under the working time regulations or a dismissal because of a to-be transfer, unfair dismissal is used as a mechanism to uphold those EU protections. But if we focus on the core ordinary unfair dismissal claim, so unfairly dismissed for redundancy, misconduct, capability reasons, it is a wholly UK concept and will continue to be largely unaffected following any Brexit. That's not to say that, in accordance with British constitutional theory and the sovereignty of Parliament, this UK right established by an Act of Parliament could be repealed at any time by the government of the day. But I think because it's been part of the employment law landscape for well over 40 years and is arguably hardwired into our labour market, I can't see there's any political appetite at the moment to further erode what many employees see as a cornerstone of their job security. I think that's all we have time for today. Apologies if we haven't had time to cover your question. We'll be posting updates on Brexit on our Employment Buddy blog, so make sure you take a look at those. All that's left really now is to thank you very much for listening, and let's see what happens on the 23rd of June. Thank you for listening.